Hey everybody, this is Derek Cohen, Deputy Director for the Center for Effective Justice at the Texas Public Policy Foundation, and with our Right on Crime campaign. I'm very pleased to be joined by two of the brightest minds in the civil asset forfeiture debate right now. First we have Brad Cates, who's an attorney living in Las Cruces, New Mexico, former legislator as well. Brad Cates was also a long-time serving director of the Department of Justice Civil Asset Forfeiture Division. Next to him, we have Lee McGrath. Lee McGrath works for the Institute of Justice, where he serves as legislative counsel. Welcome, gentlemen. I'm glad you both could be here.
Glad to be here. Thank you.
Derek, my pleasure. Thanks for organizing this.
Oh, well, believe me, if we have the opportunity to bring such great minds together, then it's definitely behooves us to do so. So I'd like to start off, and for those of you listening, we will be joined shortly by John Malcolm, the director of the Edwin Mesa III Center at the Heritage Foundation. He's just having a little bit of issues with the login link, and he's also going to need to. He has a freestanding commitment that he's going to need to leave about 10 minutes early. So if you have any questions dedicated for John, please ask those towards the beginning of the question and answer section. Secondly, when you do have questions in the question and answer section, please make sure you type them into your browser, and then they'll show up here on my computer, and I'll be able to ask them directly of our panelists. So without further ado, I'd like to actually start off with you, Brad. So Brad, can you give us a little bit of your background and tell us a little bit of how civil asset forfeiture came to be, specifically in New Mexico, and then in the federal government writ large, and the role you played in that?
Well, I was the director at the Justice Department's office, the second director, in fact, when it was just being founded. The laws were new, the Crime Control Act, the Money Laundering Act, these were all new, and we were creating it as we went. Asset forfeiture applied for 200 years, basically, only to import customs matters, and then we creatively expanded it. And so that by the time I left, there were about 200 laws that it applied to, and now I'm told there's 400. So we have this huge expansion with a policy that was really designed to hit big-time drug cartels. We didn't have the terrorist issues we had today, but these drug cartels were moving big money, as we remember from our Miami Vice programs back in those years. And we thought we were doing good, and we did do good, and I was pleased with it. But what we've done is taken an exception, as it were. Asset forfeiture has always been an exception to jurisprudence because it applied at the border. And as we all know, the movement of peoples in and out of the country, you can have your things searched. There is no probable cause requirement. A border search is different than the rest of our jurisprudence, and that's where asset forfeiture was. But we've moved it inland and now applied it to 400 laws, one of the most pernicious being money laundering, which is a whole other area of law that we've grafted it onto. And between all of those, that is where it's gone. It's just proliferated, and it needs to be reined back in. I was able to work here in New Mexico with the sponsor, Ipsen New Cook, and others, and we unanimously passed it this last session to abolish civil asset forfeiture. I think all of our listeners well understand the difference between civil and criminal, but we abolished civil and we strengthened criminal. Criminal's important, I still think, and when you're convicted of a crime, the instrumentalities and the proceeds of that crime ought to be taken away from you. But as we all know, in the criminal process, all of the Bill of Rights apply to us in fair trial and all of that. Virtually none of that applies with civil, as you know.
That is true. That is true. Now, Lee, can you give us a more technical understanding about the delineation between civil and criminal? As in, where does it specifically happen? Where is the determination made as the process moves forward? How procedurally do the two paths split, in other words?
Derek, happy to. The first thing to recognize is that there's a difference between seizures and forfeitures. Police are in the seizure business. And when they have probable cause, they stop and seize property. The reforms that Brad was so instrumental making in New Mexico and are currently being made in other states really don't touch the work of police officers and sheriffs. They don't change radically or even subtly the work of seizures. By contrast, the reforms focus on forfeiture. And forfeiture is a litigation process in which the state can take ultimate title to property if the prosecutor or if it's shown that the property was an instrument or proceeds of a crime. Now, what Brad was talking about, the difference between civil forfeiture and criminal forfeiture, is important. Civil forfeiture is a two-track system. The person goes into the criminal justice system, his car and his cash go into the civil system. There are two different tracks, and in many states they're not tied together. They're completely independent. By contrast, what New Mexico has implemented and North Carolina long has had is a single process of criminal forfeiture. If I'm driving in Las Cruces or I'm driving in Charlotte and I get stopped, my person goes into the criminal justice system, and so does my car and my cash. And in criminal forfeiture, I first must be convicted of the criminal charge, and then in the same courtroom, the judge and sometimes the jury determine whether the car and the cash are an instrument or the proceeds of a crime. But the best way to think about it is that civil forfeiture is a two-track system. Criminal forfeiture is a one-track system.
Excellent, and certainly with the former not being predicated by any finding in the latter.
Absolutely.
That brings up a very good point with the two and the one track, and the way you brought up, Lee, about how certain there's certain states that do have these protections already. So you mentioned North Carolina. Can you tell us a little bit? And I know your older report, your report from 2010, speaks to this. What are some of the problems when we see states trying to enshrine protections against civil asset forfeiture?
So the North Carolina and New Mexico are unique, having this one-track system. In the other states with a two-track system, the biggest issue is first that a person could be, in theory, could be acquitted in criminal court but still lose his property through civil litigation because there's no link. These two processes are completely independent of each other. The civil case is an in rem case in which all that's up for determination is whether the car was an instrument or the cash or it was the proceeds of the alleged crime. And so because it is a narrower question in civil forfeiture, untied to criminal prosecution, prosecutors can take ultimate title much easier because there's no conviction requirement, and the standards of proof are much lower.
Excellent. Well, I just noticed that John Malcolm, the director of the Edwin Meets III Center at the Heritage Foundation, has just joined us. Hey, John, can you see and hear us well?
I can see you. I don't know that you can see me. After extreme technical difficulty, I'm here.
Very, very well. Well, as long as you can hear us, I suppose that works just as well. Well, John, I'm glad that you actually were able to join us. If you would like, would you describe a little bit of how the federal system works, the federal civil forfeiture system works, and under that, how equitable sharing kind of circumvents state policy on the matter?
Sure. So the federal government can adopt cases or work on a task force with various state agencies, and oftentimes what will happen is the state will refer the matter to the federal authorities to pursue the forfeiture matter rather than proceeding in state courts themselves. And when they do, after forfeiture is obtained, the federal government will remit up to 80%, usually is around 75, 80%, back to the states, and there is a requirement that those funds be spent for law enforcement purposes. The federal standards, as Lee and Brad may have already mentioned, are quite low. You have a preponderance of the evidence standard. There's the innocent owner defense. The onus is placed on the owner to prove his innocence. So there are very, very few procedural protections in federal court. And if there are state laws that are either more restrictive, utilizing higher standards, or that place restrictions in terms of how the funds that are forfeited can be spent, this is a way of bypassing those more restrictive state laws.
And so, Brad, how did that factor into some of the work that you championed in New Mexico?
We set a $50,000 requirement that the local agents are not permitted to do this in run. We tried to give the protections of the Constitution to our citizens, and we thought it not right that they do an in run. On the other hand, in large amounts, over $50,000 in these large interstate cases, we thought that referral might be appropriate. So that's how we made that distinction in New Mexico.
Excellent, excellent. So, Lee, we talked a little bit about the end run, the base. It's a form of a venue selection, if you will, when engaging in civil forfeiture. So, what have we seen done so far to sort of draw back some of this state and federal cooperation that we clearly seen has led to these abuses, or at least facilitated such abuses, but on the other hand, actually perform a valuable function to certain law enforcement entities? What have we seen done as a way of striking a middle balance on this?
Before he left, Attorney General Holder made an announcement about one of the components of equitable sharing that John mentioned, which was the adoption, where a federal agency takes control over a case after local law enforcement, state law enforcement has done the seizure. So that was a constructive, but yet it was a small change. Most of the collaboration that takes place between state and federal agents does not involve the old process of adoption, but rather the newer process of joint task forces. So one should not overestimate the amount of reform in Attorney General Holder's announcement. A good first step. We think it's less than 10% of the cases. But what Brad has done in New Mexico has been proposed in Ohio, and that is establishing the $50,000 threshold. Let me go into, because it's so important and because it is really reflective of federalism, let me just take another minute and build upon what Brad said.
Please.
What the law in New Mexico does, and what's proposed in House Bill 347 in Ohio, is that when there is a seizure and the cash and the vehicle, the blue book value of the vehicle is $50,000 or less, local and state law enforcement is prohibited to contract with the federal government. They can't call up the U.S. Department of Justice and engage in equitable sharing. Instead, local and state police and sheriffs must call their district attorney or their county attorney or their municipal prosecutor and file forfeiture charges against the property under state law. This is vital for all state legislators because they can work very hard to change other components of state forfeiture laws. But if they don't address the outsourcing of forfeiture cases to the federal government, they really have done nothing to address the core issue of property rights and due process rights.
Excellent, excellent. Now I know we've discussed this before, but John, we discussed this a little bit in New Orleans, and obviously we've discussed this on several panels prior too. You know, we talk about civil asset forfeiture in terms of procedure and issues where these incentives may lie. Can you talk a little bit more about the corrupting incentives, about the how this practice tends to incentivize practice that isn't necessarily congruent with first principles?
Yeah, well, look, I mean, I want to make clear that the whole purpose of this is not to deprive law enforcement authorities of the funds that they need to do their jobs. I mean, you know, most law enforcement authorities are dedicated, ethical public servants, and they operate in a very dangerous environment. They're there to keep us safe, and it's important that they have the funds to, you know, get the job done. However, it's important as well in terms of protecting, you know, innocent donors, people's property, that if this is going to be done, that it be done in a fair way of proceeding, and that, you know, involves increasing protections, raising the standard of proof, perhaps doing what they've done in New Mexico and Brad State of requiring criminal forfeiture, if not, at the very least, raising the standards to clear and convincing evidence. And one of the main reasons for this is because, to some extent, law enforcement authorities become dependent upon this cash. And unfortunately, what began as a very laudable goal of depriving bad guys of their ill-gotten gains or the property that they use to commit crimes, sometimes it's the cash and property that ends up becoming the focus of law enforcement authorities. So, for instance, they'll make roadside seizures where it's entirely possible that the cash that's found in the car is connected to drugs. But rather than taking the person into custody, leveling charges, or questioning them about the source of those funds, they'll get the driver to waive the rights to that property and send them on their way. There have been undercover investigations. There was a TV station, for instance, in Tennessee, that chronicled that there was 10 times more of an enforcement effort on the side of the interstate highway that went from Nashville down to Mexico than from Mexico to Nashville. So what was happening was law enforcement authorities were watching suspected drug dealers travel from Mexico into Nashville, bringing the drugs in and actually selling the drugs on the street in Nashville, and they were nabbing them as they returned to Mexico because that's when they would be carrying cash. And unfortunately, there are similar horror stories like that popping up in different jurisdictions all around the country. By making this so lucrative and the money goes directly into their hands, it sometimes has the unfortunate byproduct, in my opinion, of warping law enforcement priorities, where they focus more on getting the goods than getting the bad guys.
Well, that's a great segue into some of the more practical policy matters. For example, Mr. McGrath and myself were just in Nashville to testify on criminal justice reform issues. He on civil asset forfeiture, me on some different items of criminal justice reform. Lee, can you tell me a little bit about what's the landscape of the states right now, and what do you see? You mentioned the Ohio bill earlier. There is also the bill in Pennsylvania right now. Which of these do you feel is the most efficacious, or at least to your knowledge that those of you have looked into? Which do you think is getting it right? Which one do you think could be actually improved? And where do you think is fertile ground for reform moving forward?
Well, New Mexico is the platinum standard, Derek. It really has done all the heavy lifting, and it did it magnificently in one stroke. It's a real tribute to the team that Brad led and the legislators who authored the bill. But other states have followed. For example, in Nevada, in Montana, and in Minnesota, they've kept the two-track system, but required a conviction as a prerequisite to forfeiture. So in other words, the person must be convicted first in criminal court, and then in civil court, the second track, the property and the proceeds are determined to be instruments, or the cash is determined to be proceeds of the crime. So there, the extra process of the criminal conviction is added. Georgia did a nice job, as did Utah, to add reporting requirements, and Michigan just a couple weeks ago added reporting requirements and raised the standard of proof. I know in New Hampshire there's currently a bill that's gotten out of the Judiciary Committee that establishes this conviction prerequisite. And in New Hampshire, they're dealing with forfeiture proceeds. Tennessee has started their initial study of this. So a lot is happening across the country. It is not without its challenges. A lot of effort went into California for naught, but we know what the pinnacle is It's what has been done in New Mexico, and we also know what intermediate steps are, like raising standards of proof, shifting burdens of proof, or requiring a conviction as a prerequisite.
Excellent, thank you, Lee. And I'd just like to jump in real quick to remind everybody to enter your questions right there to the right of your screen. We're going to go to question and answers here shortly. And remember, because John's only with us for a limited period of time, if you have a question specific for John, make sure you flag it as such so we can make sure we get it before he has to move on to his next gathering. But I'd like to springboard off what you said, Lee, about well, not only what went down in New Mexico, but also some of the, the political process here. Brad, as one of the chief architects on the forfeiture reform effort in New Mexico, tell us what was the engagement like in terms of stakeholders, in terms of individuals who were either in support or opposed to it, and how did this either help or hurt some of the political efforts behind it?
Derek, we lucked out in New Mexico because this bill was so popular with the leadership in the legislature and the rank and file. Nobody had a chance to mobilize against this. We only meet for 2 months a year, and that's enough government for most people in New Mexico to want. And we didn't drop the bill till after day 30, halfway through, and it moved quickly and rapidly based upon the philosophical reasons. And the huge backlash that you're encountering in other states is a result of, shall I say, money. Let me say what I think is maybe the underlying problem with this whole system. There's 2 or 3. We'll talk about them today. But to me, are most of our listeners lawyers? You know that an appearance of impropriety is the gold standard of what's got to be avoided in the judicial profession. Doctors can do no harm, well, lawyers, a judge, any appearance of a conflict. When you're taking clients in your law firm, you've got to vet them to make sure that there is no appearance of impropriety. And while the police aren't themselves lawyers, they're an integral part of the judicial system that lawyers, prosecutors, do control. So we have, I think, a fundamental ethical violation by the prosecutor offices sharing in the decisions that they make. They take this money, and it has now become 10, 15% in some states. But it doesn't matter whether it's 1% or 15%. The appearance to the person from whom the money is taken, the appearance is that the system is corrupt against him. And this weakens the respect of citizens toward our whole legal system. You ask, how did this come about? There is vague language in the authorizing federal laws from the 70s about this law enforcement need. There are no comprehensive CFRs on it. It's merely a rule that was made up in the Asset Forfeiture Office. This needs to be abolished, and there should be no appearance, like in the old JP system where the judge got the ticket money. It looks wrong. It looks like corruption. And whether or not there's examples, like in Lee's new book, there's hundreds of examples, and in the Washington Post story, but examples are not, it just looks bad. So there is that aspect, and integrally tied with it is that the people's representatives, that is, their state legislators, are tasked with funding the government. And there are many important needs we know of. I mean, there's potholes, there's teachers, there's a myriad of needs, and in my view, at least, law enforcement is amongst the top needs. But legislators need to vet every application from the local offices to the DAs and come stand before them with the teachers and the pothole fixers and get an appropriation. They're elected by the people to appropriate. They need to appropriate, not have a side channel to getting money. And as I say, whether it's 2% or 15%, this is a major source of apparent impropriety, and it is a major source of weakening of the people's representatives' power to appropriate.
Certainly, certainly, and I believe Hal Stratton, former Attorney General, former New Mexico legislator, said that just the same thing when we were discussing with this on a panel with him in New Orleans. Lee, I'd like to have a more applied focus on what both Brad said and John said earlier. So we have this allegation of corrupt incentives. I believe your organization's actually done some work on that.
We have done a study, Derek, in which we looked at the problems of incentives. Law enforcement often testifies that there are few bad apples. It is not a problem of just a few cops going rogue. It's a systematic problem of incentives. And so what the Institute for Justice has done is looked at state laws across the country, looked at the inherent incentives, and graded them. So today we released the second edition of our study, Policing for Profit. It weighs about 2 pounds, and it got a state-by-state analysis of forfeiture laws, well cited. So it should be for all listeners of this program. You can see it on IJ's website, and if you'd like, I'd be happy, or one of my colleagues would be happy to mail you a hard copy. It documents, for example, just the magnitude of growth there. On the federal program, it showed that in 2001 there were $500 million in federal forfeitures. Today they're $5 billion. So as John and Brad have pointed out, this is a growing problem. There's federal issues, there's states issues, there's federalism issues.
That's actually a great point I wanted to focus on. John, I know we only have you for a few more minutes, and I'd love to give you an opportunity to weigh in on that and also to answer any questions we get for you. But before we do go into question and answers, from the Heritage Foundation, obviously one of the eminent conservative think tanks of our time, why are you, or should I say, why is the Mies Center taking the position it is? Where does that differentiate a little bit by some of the others, perhaps on this call? And can you delve into a little bit of the federalism discussion and how that's abdicated by civil asset forfeiture?
Sure. Well, look, I think that property rights are very important, and to me, procedural fairness and respect for our criminal justice system are incredibly important topics. Yes, civil asset forfeiture is technically a civil proceeding. However, even the Supreme Court has called this a quasi-criminal proceeding because all of this property is supposed to be connected to crime. But before you are going to deprive people of their property, you need to have a fair system that gives them a legitimate chance of having the government bear the burden of proving the connection by a high standard between that property and illegal activity, and proving that the property owner was somehow complicit, or at the very least willfully blind to how his or her property was being used. And if you have a system in which the government can come in there and, based on probable cause or a mere preponderance standard, and make an ex parte showing to some judge and say, okay, or perhaps even before an administrative law judge, most of these proceedings are handled administratively, where the government is essentially the investigator, the prosecutor, the judge, and the jury. You need to have some procedural fairness that is lacking. Now, one area where I may disagree slightly with Brad and Lee is that they have held up the need to have a criminal conviction as the platinum standard. And I would say, look, that's probably true, but there are instances in which a defendant dies, or perhaps is a fugitive from justice, or is outside of the jurisdiction and can't be brought into the United States, or where the property is simply found in the vicinity of drugs and there's nobody around, and certainly once the police are there, nobody's going to show up, or if somebody is immunized or a case is dismissed for procedural irregularities, in which a forfeiture may still be justified, and you would not have a criminal conviction. Even in those circumstances, however, the process needs to be a heck of a lot fairer than it is now, because as it stands, the procedures are skewed in every possible way against innocent owners being able to get their property back.
I actually think, and John, since we still have you, I'd actually like to ask you to follow up on that. Can you talk a little bit more about innocent owner? Because we've seen both here in Texas, and we've also seen in other states, an attempt to reinvigorate the innocent owner defense. You know, something that came through with CAFRA in 2000 and was, subsequently neutered by Venice v. Michigan. Can you talk a little bit about innocent owner provisions as a standalone and what they do to affect the process?
Yeah, so the government comes in now and it says, well, this is a civil proceeding, and the standard burden of proof in a civil proceeding is preponderance of the evidence. So let's assume you get to court, that you're not one of the 80% of cases that are handled administratively before an ALJ who doesn't even have to justify a decision. So now you're in front of a judge, and the government comes in there and presents whatever evidence it's going to present, hearsay evidence, etc., and says, well, okay, by a preponderance of the evidence, we're going to connect this property to some illicit activity. Maybe the property owner wasn't involved at all. It could be somebody like, say, Russ Caswell, which was a case handled by Institute for Justice, who owned a hotel in Massachusetts and had operated for years, and on a small handful of occasions, a drug dealer had utilized one of the rooms that he had rented in order to deal drugs. So the government comes in and says, well, we've tied this entire hotel to drug dealing. It's facilitating property. Now you, Mr. Caswell, you have to come in and you need to prove to the satisfaction of the court that you had no connection to this illicit activity, that you hadn't permitted it, you were unaware of it, and that if you were aware of it, you did everything you conceivably could have done to have stopped that illicit activity. It requires the property owner to prove a negative about what he didn't know, and what he could have done had he known something. And, it's an incredible burden to place on a property owner who's sitting there and saying, hey, I had nothing to do with the crime. This was my property. I didn't know it was being used improperly. Give it back to me. You have no right to take it.
And that's definitely a fundamental illustration of one of the problems that forfeiture brings about. Now, I'd like to go to Brad and then Lee with the question that John just posed. When it comes to dealing with the abolition of civil asset forfeiture, certainly there's going to be exceptional cases that require certain procedural workarounds. How could you meet, or at least under the current rubric of New Mexico, or the gold standard, how could we meet the special nuances of these cases, I guess is the easiest way to say it. In other words, how can we address abandoned property? How can we address people who abscond and still actually see forfeiture what is clearly a criminal enterprise?
I think there's several ways to do that. As Lee said a while ago, none of this affects the work of police. An abandoned piece of property has a pre-existing procedure for how abandoned property is taken. Property moving into the country, as I explained earlier, has a whole set of different rules about what is allowable than interior searches. So instances where there's an airplane flying in or cash unaccounted for as it moves across the international border, that's a different system that's accounted for. Contraband is per se taken. I don't want to use the word forfeit. It's not forfeited. It's taken by the state. Evidence is taken by the state. When someone is arrested, the evidence is taken at that time and is held for the completion of the case. So in all of these instances you mentioned, the property can be seized by the police and held by the police and the prosecutors through the entire system without interruption. Now, there's another piece to this that I think's serious though as well, and that is this amount of money that is being seized this way. I will cite and not go into it, but 4 instances recently have come to my mind. Hal Stratton, who was referenced, and I did a radio debate with the sheriffs here in New Mexico recently. The other day, before the Pennsylvania Senate, the president of their association, of the DA's association, spoke. And in this last weekend, there's a bill pending in Oklahoma, and they did a debate between the sponsor and the District Attorneys Association. In all 3 of these cases, what the detractors of our efforts do, what they've said is, we know that this guy's a drug dealer, but we couldn't get enough to convict him. but we're going to get them anyway. Doesn't that offend you? It really offends me. I mean, in Brazil and places, we know how there's extrajudicial getting of people that they know are criminals. And I've been a prosecutor frequently in my life, and a lot of people I knew in my gut was a criminal. But there's a right way in America to make a conviction. And these people, these cases you talk about, this guy's probably a drug dealer. There's probably illegal activity. There's probably this and probably that. We have a procedure to deal with that. The right way, the fair way. And taking it as we now do it because the prosecutor knows that this man's a drug dealer just doesn't cut it under our American judicial system.
Well, Brett, I hate to jump in, but unfortunately, ladies and gentlemen, John Malcolm, who was so gracious to join us, does have a pre-existing engagement. But before he scoots on off to that, I'd like to just say thank you, John, and ask if there's anything you'd like to leave us with.
No, look, I think this is a very important topic, and I'm pleased to be on this panel with three such dedicated reformers and very, very bright people, and it's been a pleasure participating in this. Thanks for having me on.
Derek, before John goes, let me just, because the viewers cannot see it, let me just hold up the Heritage Foundation's terrific little booklet about arresting your property. And I'm sure if viewers wanted to contact the Heritage Foundation, they'd send a copy of this. Most impressively is the back page, which shows all the various organizations that are working with Heritage and the Institute for Justice on this advocacy.
Thank you, Lee. It's definitely available online at Heritage's website. And with that, I got to run.
Excellent, John. Well, thank you very much for joining us for the time that you did. So I just wanted to remind everybody, we got a few questions coming in. We only have about 8 more minutes left. But if you have any questions for any of our panelists today, feel free to post it, and I will definitely make sure to ask it. So here's one question posted thus far, and I'd like to shoot it towards you, Lee. So it's basically, and we have touched on this already. It says, well, what if we got rid of civil asset forfeiture? Wouldn't this affect the police ability to seize drugs, and even if not seize drugs, to punish those who would be bringing drugs into our communities?
I think the answer is undoubtedly no to that, Derek, because police only need probable cause to do a seizure. They can get the drugs off the street. They can take the drugs and have them destroyed, even independent of a forfeiture process. As Brad suggested, illegal drugs, contraband, are per se illegal and can be destroyed once their evidentiary value no longer exists. So law enforcement should be working both sides of the highway. It should be, if it wants to punish drug cartels, international criminal syndicates, it can do that just as equally by working the eastbound side of the highway and taking the product before it sells. It shouldn't, as reports in Tennessee and Oklahoma have shown, just be working the westbound side of the highway, claiming that the cash is the way to undermine the cartels.
Well, we have another question here. It just says preponderance question mark. So I'm going to repurpose that. I'm going to say, Brad, we do talk a lot about the different evidentiary standards here, everything from preponderance of the evidence to clear and convincing evidence, and to beyond a reasonable doubt, as that would be which would be required for a criminal conviction. Can you, in the best you can, address to the layman what these different standards mean and what it means to satisfy these standards?
Well, without giving a law lecture on the subject, there are 4 or 5 different levels in our judicial system of what must be proved. And there are different steps or different stages at which different parties have to prove different things. And I think Lee, though, in the context of what we're talking about today, just explained it best. The police on the street only need probable cause. The light bulb is out on the tail light of your car. They make a stop, and from that stop, things can flow, but they have to have initial probable cause. They only need probable cause to make seizures. Seizures of drugs, of contraband, of evidence, a pile of money. And this probable cause is the lowest of all the standards. And once it's seized, we in New Mexico and the reform proposals then give the prosecutor several avenues to properly take the property. But it is not right that someone have their property. I mean, in the original constitutional documents, it's life, liberty, and property, one and indivisible. And our property, as the Magna Carta laid out, is an integral part of what we are. And our property, persons, and life should not be taken without a proper due process under our Bill of Rights. And a citizen should not have to come forward and prove anything. They have a Fifth Amendment right to be silent. Nothing. They have no burden whatsoever under our criminal justice system. And to circumvent that because someone knows they're a drug dealer is not sufficient, in my view.
Excellent, excellent. Well, here's a great one, Lee, that I would like to pose to you. It says, well, what can we do to work against this? I assume they mean against the practice as is.
Well, it is hopping, Derek, at state legislatures across the country, and the coalition is broad. The ACLU on the left has played an amazing role in state after state. The Cato and Heritage and the Institute for Justice. Once again, on the left, our friends at the Drug Policy Alliance, and so almost every think tank, every legal organization is supporting reform. There's a new coalition for public safety that has brought many of these organizations together. The only people who are opposing reform today at state legislatures are those who are receiving forfeiture proceeds. Now, the police and the prosecutors are formidable political foes, but they stand alone. And it is so intuitive to the public and to state legislators that a person who is acquitted in criminal court should not lose their property in civil court. How do people get involved? Well, I would suggest you watch the judiciary committees in your state legislatures. See what bills are being introduced to reform forfeiture. Challenge the state legislators to do more. Address the ultimate question, which is, where is the money going? But there are dozens of states that are considering forfeiture reform, and it really is wide open on the state level.
Well, we have time for just one more question, and I'd like to send this to Brad and then get your input as well, Lee, if you have any. But one that points out the issue with messaging. I mean, I think John hit this nail right on the head. Nobody here is anti-police, anti-prosecutor, and they feel that they should actually be generously funded through the appropriate appropriation strategy. But how is this message so that it isn't anti-police, anti-prosecutor? Brad.
It's frustrating to people like myself. I was a legislator for 8 years and was at the Justice Department for many. I've been a state prosecutor, and I hate crime. That's the very essence of why we form a government. I mean, isn't the protection of the people from crime, isn't that the essence of why we have a government? I hate crime, and all my life I've been an ally of the police, and I've been a prosecutor. And what is frustrating to see is what, for example, happened in California. They have I think, 40-member Senate, and the reform bill passed with only one vote against it. And then the prosecutors and police mobilized and it lost on an assembly vote, the reform in California. They have tremendous power. Nobody, not conservative Republicans, they don't want to be seen as soft on crime. And I think your liberal Democrats who perhaps represent police in big city unions, they're sympathetic to the union desires to keep this money flowing, and it's very frustrating to those of us who hate crime to explain that we're still allies of the police. We still want to stop drug cartels. We don't want this. Is anyone listening in our audience who hasn't had someone in their friends or family, someone's life ruined by drugs? It's a terrible thing. We want to stop it. But you know, what's the current most terrible thing probably in our criminal justice system? Child porn, right? And we all hate it. But I guarantee you that within a mile of your house, if we searched every computer, we'll find some child porn somewhere. Terrible thing. But still, we don't authorize the police to go search every house within a mile of you. You got to have probable cause. You've got to do it properly. So no matter, it's not the end. The ends don't justify the means, as they say. The means are our constitutional system that makes America different than the rest of the world, that makes us stronger, that protects us. And we undercut those for this exception and this exception and this exception. The exception eats the rule.
Very good, Brad. Lee, same question.
Derek, the one thing that I would add to Brad's observation is that everyone on both sides of this debate, on both sides of legislation, believes that someone who is convicted of a crime does not have a right to the fruits of that crime. What the debate is all about is whether there is a conviction requirement, and then if there is a conviction and if there is a forfeiture, what to do with the proceeds. So the ends about taking ill-gotten gains away from criminals is something that is universally held on both sides of this issue.
Excellent. Well, gentlemen, we're a little bit over time. I would just like to thank both of you and John in absentia for being able to join us here today. I think we really had a fruitful conversation, and hopefully we'll be able to discuss this further going forward. I can say that in addition to the reports that John and Lee mentioned, feel free to go to rightoncrime.com or texaspolicy.com to keep up with what we're doing either in the state of Texas or nationally on the issue. And other than that, we look forward to hearing from you.
Derek, thank you. And let me just add that the Right on Crime team, you and Mark and the entire group in Austin is playing a terrifically important role in advocating for justice and for property rights. So I'm thrilled to be part of this presentation and to continue to work with the Texas Public Policy Foundation on forfeiture reform.
Excellent. Well, thank you very much. And Brad, we are glad to have you as well. Your depth of experience has really moved forward the conversation.
Thank you for having me. I appreciate it.
All right, everybody. Until next time.